Yeah.
Okay, thank you. You're welcome. Hey,
Hey,
Brad.
hey.
Hello, hello. Just grab this one for now. Yeah,
Okay, gotta bring my glasses, thank you.
if we get to that one, we'll,
Oh, this is the long one, okay?
hand it out.
TV, bro. Hey.
Yeah.
My glasses are fucking smart. Smart.
That? Oh, I haven't got it.
Yeah, I talked to him, right before I talked to him, actually, I talked to him since then. He was in here. I don't know.
It's not the mega flight or anything.
Yeah.
It's all the feedback.
Oh, it is.
You just go back.
Yeah, yeah, yeah. Awful contracts.
Right.
Investment fund. How you been doing?
Good, how about you?
Hey, one day at a time.
You,
So,
you know it, you know it.
if-
So I gave you the marked up version of, so these are things that have changed. Just to be aware of that. So when you look at the actual offer to purchase, it's gonna look a little different than this one because this says these are the things that have changed.
Okay.
But I'm gonna go through and, just kind of explain them, to you as well. Reminder, if you have been in my classes before, this may be repeated. Yet just a reminder that on our seller, we always want to use proper names. So no abbreviations, no nicknames, that sort of thing. For both buyer and seller, make sure you're using their proper name. If it is an entity, the entity is the seller. If it is a trust, the trust is the seller. Not necessarily the person that's on the deed when you go in to search the deed, nor the person that's on the tax card. Just remember, dead people can't own property.
Right.
So
I got one like that now. Yeah.
yeah, so if it's in an estate, a trust, any of those, that's who the seller is, not the deceased individual. Same thing for buyer. Don't use a nickname or, what's on their driver's license number. What's on their driver's license card is basically what we're looking for because that's what the lender is using and that's also what the attorney is using. So if they have a nickname of Sonny, and it's nowhere close to what their name is, they can't identify that person as Sonny other than, sometimes those, like, big sisters will call the little sister Sissy or, something like that. Yeah, it has to be their real name.
Something you don't like.
Yeah, yeah, exactly, yeah.
Not no more.
Yeah. And then do it in public. So, the next part is just, you're identifying the property. Again, put as, much information in this section, that you can. All of this information, with the exception of the lot unit and block section, are on the tax card. So no reason we shouldn't be fully completing this information. Couple of things, we want to make sure that our buyer knows what they're buying and we're identifying the correct property that the seller is selling as well. PIN, again, all of this, it may not be in a subdivision, it may not be a condominium. If it's not, then obviously you don't have anything in that. Other description is your legal description on your tax card. It's usually in that, well, it depends on which tax card it is, but in that middle box that sometimes it'll say lot 1-3, you know, whatever. That's your legal description. So that would be your other description. And then, deed book and page. Sometimes I have people say, there's not a deed.
Oh, is it?
There's always
Man.
a deed. Yes, there is always a deed. And what we're looking for is the deed of the current owner. Because I had some agents that in command, when I'm like, you're missing the deed. And they're like, well, it hadn't closed yet. I'll load it when, not the deed to your new buyer. The deed, again, can that person convey the property? So the deed in the current owner's name. Property will or will not include a manufactured or mobile home. If it does, then we want to use additional provisions, addendum, to identify the VIN number and all of that property. Property will or will not include an offsite or separate septic lot, boat slip, garage, parking space, or storage unit. Typically, we will, in our area, we will see offsite or separate septic lot. You know, sometimes in some of these subdivisions, they have, you know, there's really good soil over here. So they ran the lines to the different lots. So like if you're on lot 28, then your septic might be referenced as 28A. Because that's where your septic is. So if that's the case, then you would check that it will include, and then we also use additional provisions addendum to identify.
I'm
that
okay. I'm in
property.
a forms class. So hang on just a second. I'm trying to make sure I'm not.
You're muted. Yeah, thanks, Alice. No worries. Additional parcels. So if there are additional parcels that are subject to the contract, either attach them in an exhibit. Does not include this one up here. This would be if there are multiple parcels that are being purchased, like as a package deal. Let's say you got three lots, and they're being sold as a package deal. That's where you can attach an addendum with the PIN tax information for all three of the lots.
What about like the underground, like cables or something like that, like cross the property? How would that work? there?
So that would just be an easement.
Right.
So that's typically covered as a utility easement.
Okay.
Yes. Yeah. All right. Let me see if I can, oh, I got it right first time. Okay, so on purchase price, obviously, so on D, the top number minus all of the rest of the numbers in there should equal the bottom number. So just make sure if you're negotiating and you change your purchase price, make sure you go down and change the balance due as well. Or if any of those numbers change within negotiations. It got they made a note on loan assumptions. So we may start to see some loan assumptions because those people that bought during COVID and got those great ridiculous 2 point whatever interest rates, and now they need to sell. It's that makes their property very enticing for someone to be able to assume their 2% loan as opposed to 6.5% right now. So we may start to see some of those. We do have a loan assumption addendum. Again, we want to make sure that we are in close communication with an attorney on this as well. Just as far as it's not a standard sale. So when it's an assumption, because the attorney's going to have to communicate with that lender, and they've got to get pre-qualified under that lender and all of those things. So just keep that in mind. Seller financing, we do have a seller financing addendum. However, I encourage you not to use it. It is very basic baseline. It does not dig into all of the potential things that could be with seller financing. Because the seller might say, okay, I'll accept this, but then I want a balloon payment at this time. And then what happens in default and those sorts of things is not really covered under that standard form. So I would encourage you to have an attorney draft that for clarity. It also doesn't give you an amortization schedule. Whereas when an attorney drafts it, it will do that. So a couple of things that I like about this new contract is, number one, it's only 14 pages. I mean, I know, even though it's only 14, but at least we're moving in the right direction
That's it.
of having fewer pages. I like it because, it reads as the eye reads, and it also has all of the main stuff together. Instead of, so seller concessions is now on page 1. So essentially now you can reference page 1 and all your stuff is right there. You don't have to flip to page 7 and see, oh wait, what were the closing costs? That sort of thing. So you've got it all right here, all of your terms right here. Again, we want to put a definitive number in all of these, whether it is a flat amount or a percentage. If you're on the buyer side, I encourage you to always check with the lender before you start negotiating seller paid closing costs and make sure they're allowable by the lender and what the percentages are. Because you might put $10,000 seller concession to the buyer, but the lender only allows 7 or whatever, whatever the case may be. So, essentially your people just lost $3,000 that they thought that they were going to get. Now they're not getting. Could we have used that $3,000 to negotiate the price down and then have the $7,000 in closing? So they would have realized the full 10. So on the buy side, just make sure that that you are having the conversation with the lender. If you're on the listing side, don't ask any questions. Because just remember who our fiduciary is, and it's that seller. And if they come up and say, oh, well, we only allow 7,000, the seller just got to keep 3,000 and you're the hero. So due diligence period. And again, it tells you to put a date or a number. Do not put NA. So even if the buyer says we're waiving the due diligence period, then either if you're going to use a date, put today's date, because at 5 p.m. okay, due diligence is over, or 1 day if they're waiving. Now, that doesn't mean that they still don't have the right to have inspections. They can certainly continue to have inspections. It's just that that's when the due diligence period ended. And if there were additional earnest money, that's when that money would be due as well. And you can use either one of them. It does not matter. You can use a date or you could use X number of days. Either one is fine. I kind of like the X number of days, just simply because, I mean, we're kind of in a situation right now where we have agents, that have offers in hand that aren't responding. And so if I put a date in here and the agent doesn't respond for 4 days, I've just lost 4 days of my date unless we modify that. So, 21 days after the effective date is the same as whatever, hard date that would be. So just know that. Settlement date, again, we've just put all of that stuff together. And then we've got all of our, stuff that still matters, more of explanation. So we've got all of the negotiated things on page 1. Earnest money deposit, again, they've just reminded the buyer that, if there is a, dispute, then, the escrow agent can, turn the money over to the clerk of court. If the buyer and seller are, not able to resolve the dispute, they turn it over to the clerk of court. And then if I'm the seller and I think, well, I should get it, and it's very clear to me that I should get it, then I go to court before the magistrate and say, this is the reason why I am owed this money. Escrow agent, make sure you're putting the escrow agent in here. If well, you can put it in there whether there's earnest money or whether there's not earnest money. If there is earnest money, you have to identify who that escrow agent is at the time of offer. So knowing that, okay, we're going to use this attorney for closing, and that's the name that you would put in there to hold the earnest money as the escrow agent. If there's no earnest money, again, you don't have to put anything in there, however you can. Effective date, so they're just, again, these are just a lot of definitions, that we usually just, we don't read through it with our buyers or our sellers. We just say, okay, the effective date is the last date that everybody has signed, the last person has signed, because our dates are tied to effective date. So if we look at our due diligence date and it says 21 days, it says 21 days after the effective date. So just making everyone aware of what the definition of effective date is. Now we're defining due diligence, the buyer's opportunity to investigate the property, due diligence fee, again, talking about what due diligence fee is, and that due diligence is non-refundable with the exception of a seller breach or the buyer goes to closing. The only 2 times that that due diligence monies are could be refundable. If a buyer indicates that they believe that there is a breach either by the listing agent or by the seller, then they have to contact an attorney. That's not something that that we want to get in the middle of trying to resolve, because it's always going to be, well, your seller had to know that there was standing water in their crawl space. And I'm like, well, my seller didn't know because my seller doesn't go in his crawl space, kind of thing. So, and then it becomes, what should a person reasonably have known, all of that. So it gets very in the weeds at that point. So, if a buyer says, we want our due diligence money back because of breach, then they need to contact an attorney, because that becomes a civil matter at that point. Then it defines the difference between settlement and closing. Settlement and closing are not the same. Settlement is when we're getting everything ready. So the title search is being done. the loan documents are being sent to the attorney, the deed, the seller signing the deed, you know, and then we all have this little party at the attorney's office. That's settlement. Most of the time the sellers don't even go anymore, but anyway, that's settlement. Closing is when the attorney sends you that email and says, we're recorded, you can come pick up your check. That's when you do the happy dance. Yes, so closing means everything has been done, the loan has been funded, everybody, all of the monies have been dispersed where they were to be dispersed. And the ownership has been transferred. So I say that in, you know, a lot of times, I won't say a lot of times, occasionally we go to closing, you know, the buyer thinks they're gonna get the keys at the settlement party. Right, so we just don't wanna set the expectation that, you know, oh yeah, you're gonna walk out from the attorney's office with those keys in hand. No, this is what has to happen, and then you get the keys. And I say that because, you know, a couple of things. One, what happens if that lender doesn't fund? Now you got a buyer that has keys to your house that they do not own. And then what happens if that buyer moves in and they catch the kitchen on fire the first night they're in there? Now you have a house that has fire damage that somebody else is living in that they don't own. So just the importance of not delivering keys until closing has occurred. And unless the seller authorizes. If the seller authorizes, then I would strongly encourage you to do a buyer possession prior to closing. So that's why they call it buyer possession prior to closing, not buyer possession prior to settlement. Even if it's only just for a day or a weekend, we were supposed to close on Friday and the lender couldn't get their act together, and now it's not going to close until Monday. And the buyers are sitting there with all their furniture in their, in the moving truck. We're still not going to hand those over without there being some sort of document. That buyer possession prior to closing is what protects the seller from all of those things that I just talked about.
In that scenario, could it be negotiated at that point to, you know, have the possession early?
Yeah.
Oh, it still could be, okay.
Yes. Yeah, absolutely. I mean, because, literally, they probably didn't know until, you know, it's like everybody thinks we're going to the settlement party.
Right.
And then we get to the settlement party and some person didn't do a part of their job in order for us to proceed to the closing party. So yes, it can definitely be, negotiated. I mean, I've had it happen several times, you know, when we're sitting at the settlement party and it's like, okay, this is not gonna happen today. And, you know, and then the buyers are like, oh, we have all of our furniture in the truck, and, you know, and so, you know, working it out, from there. Attorney closings in North Carolina. This is just a reminder that in the state of North Carolina, an attorney must do the closing. It cannot be a paralegal. Typically, the paralegal does all the work. Yeah, till you walk into the settlement party and then the attorney shows up and, you know, at that point. But just a reminder that it has to be an attorney, and I would just caution you on some of these traveling attorneys or attorney companies. Just make sure that it is actually the attorney that's showing up, not a paralegal. This is as a result of, you know, this office was hit a couple of different times with Washburn Law and their illegal acts and, so, well, they're not licensed anymore, so.
Yeah.
Well, there was a couple of things that happened. One, they weren't recording deeds. And two, they weren't dispersing proceeds to sellers.
Wow.
Yeah.
Hmm.
Yes. So just a reminder on that. Special assessments, essentially all they've done is they took special assessments out of this area of prorations that are like taxes, owners associations, that sort of thing. And they moved it to another section. So we'll get to it when we get there. Fixtures and exclusions. So anytime the bar in conjunction with NCAR and the Real Estate Commission put something in red, it means that they want you to look at it. There for a while, they put boxes around everything and there were 14 boxes all over the place. Now they just put it in red. Parties should not assume that an item will or will not be included in the sale based on a statement or advertisement outside of this contract. So if the MLS sheet says the refrigerator remains, don't rely on the MLS sheet. Make sure you put it in the contract as well. All of these things that are on this list convey. Whether it's a smart version, a dumb version, either one, all of these things convey. We want to make sure we're reviewing that with our sellers at time of listing and also with our buyers. These are the things that that are going to come with the house. We don't specifically have to ask for all of these things. And the other part of this is if the property does not have one of these items, there's no need to cross it out. You don't have, like, if it doesn't have a basketball goal or play equipment, don't cross it out. It's just, if it does, it stays. Y'all laugh. You'll be amazed some of the things I see.
I was bad. Bad as I thought it was.
Right. No more than I thought you did. Unpairing and deleting data from devices. This is very important to remind our sellers to unpair any of their devices that are conveying. So here's the scenario, a couple of scenarios. Number one, so in my car, on that part right up there, there's 3 buttons. And I can program my garage doors to those 3 buttons, and I don't have to have my physical garage door opener, right? So when I move, I have to unpair so that I can't drive by the house and hit the garage door opener. And yeah, I mean, so here's my scenario that I use is that I just moved to a different property in the same neighborhood. Okay. And so I'm driving down the road and I'm like, all right, yeah, I'm gonna go ahead and hit my garage door opener. About the time that I'm passing my old house, the garage door comes up at their house. Somebody goes in and steals all of their stuff. Yeah, we don't want that to happen. The other thing is any type of video surveillance equipment. I would hate to think that I moved into my new house and then come to find out they forgot to unpair the baby cam, and they've been watching me for the last 30 days or whatever. And I mean, that can actually be a felony. I mean, like, they can go to jail for that, even if it wasn't intended, it was accidental. But again, that's one of the things we want to make sure. So when you have your, like your closing checklist for your seller, where you remind them to, cancel the trash, schedule to have your utilities cut off the day after closing, cancel your homeowner's insurance, all of those things that you're reminding them to do before closing. I would put that, and I would put it in bold or highlight it or whatever. And then, okay, now let's make sure you did all of this, as you're going through it. Because it can be a very big deal. Items that are leased or not owned, so this might be satellite dishes, receivers, appliances, alarm systems, solar panels. It may also be HVAC units. There's several things, so we want to make sure on the list side that we are asking our seller, do you have a lien, or any of your, if they say, this is where I would, oh, we just had the HVAC unit replaced last year. Great. Did you pay for it in full, or is it financed? Asking those questions, because there are some HVAC companies out there that will do, they'll do financing. We just need to know, because obviously that needs to be paid off. That will be paid off at time of closing. Usually antennas, satellite dishes, receivers, they don't want them back. But we do, if they're like, okay, we're not gonna use DirecTV, we're gonna use Spectrum or whatever the case may be. They typically, DirecTV doesn't want them back, yet call DirecTV when you're calling to say, I want to cancel the service as of this date. If they want you to send it back, they typically send you a box to ship that back in. Appliances, same thing. That's why we have rent-a-centers, right? Because same thing with the HVAC unit.
I think you must be talking about your phones. I'm going to get my glasses. I'll be right here.
So, same thing, there might be, even though it says up here that, the range conveys, they might have a lease agreement with Rent-A-Center, and they don't actually own the range. So again, just, or the refrigerator, oh yeah, we're gonna leave the refrigerator, but we forgot to tell you we don't own it. So just, making sure that we're asking, are there any items, leased? Fuel tanks typically are leased, so they did change the verbiage on that, a little bit. So any items leased or not owned by the seller that seller wishes to convey, I already got you one. Under certain conditions. So if the seller wishes for the buyer to assume a fixture loan before conveying, then it needs to be, that needs to be addressed, with a, and it would have to be an attorney drafted addendum, or the addendum for, solar panel. So typically your Rent-A-Centers are not assumable. Typically your HVACs, those things aren't assumable by the next person, so they would need to be paid off. Solar panels are the one thing that are assumable. And it gets a little tricky with solar panels, because the buyer has to qualify. So not only do they have to qualify for the purchase price of the house, they also have to qualify for the purchase price of the solar panels. So if you've got a $10,000 lien owed on solar panels, buyer has to be able to qualify for both of those if the buyer is assuming them. Typically, I would want the seller to, first of all, when did they fall and bump their head and decided that solar panels were going to be a great addition to their roof? And, and then secondly, It's not like the buyers are out there chomping at the bit, like, I want a house with solar panels
All right.
on it, you know? So in our area, they aren't, particularly, popular. So again, if so, if those things are being assumed by the buyer, then we need to take it a step further. Conversation with the lender, conversation with the attorney on what that looks like. Any items that, do not convey, and then just a reminder that the seller must repair any damage caused by removal of any of the items excluded above. Again, from here, I always say, if something's not going to convey, make it go away. So if grandma chandelier is not staying, get grandma chandelier down before pictures. Don't even have it in the pictures, and have it replaced with a like kind or something that suits the price point of the house. Don't go to Lowe's and buy that $35 brass 3-stick thing when,
It look like a spaceship.
Yeah. And then, of course, anything that's removed, then, they would just need to, make sure that it's repaired. If for whatever reason, when you show the house at time of offer, you are, your buyer wants to write an offer and they're like, oh yeah, we're gonna repair that. That's when we kick in that additional provisions addendum that says, we've got it in writing that you're going to repair it. So personal property, this is another thing that I see that's redundant. They changed so the verbiage is a little different on here. The following personal property present on the property on the date of the offer shall be transferred to the buyer at closing at no value. So a lot of times I'll see refrigerator or fridge, which really makes my eye twitch. Again, when we talk about not using abbreviations, jargon, that sort of thing. It's fine, Anthony, you can come in this way. I won't bite you. Please spell out refrigerator. Even if you spell it wrong, I don't care. Just don't put fridge.
I do that a lot.
For washer, you gotta spell out washing machine.
No, just washer dryer, fine. I'm fine with washer dryer. Yeah, it's just,
Just refrigerator.
yes,
question,
just,
Scott.
just refrigerator, yes. And again, this is conveying at no value. So, this is, we're not getting into high ticket items here. This would be refrigerator, washer, dryer, draperies, even though draperies can be very expensive. Yes, yes. It might also be,
Generator.
it depends on if it's attached or not.
Yeah,
If
like
it's,
not that.
if it's not attached, then yes, you could put that on here. When we start getting into like, zero turn lawnmower or, John Deere tractor, those sorts of things. There's a separate form that we would put those on that are outside of the closing. So essentially it's a bill of sale for items, whether there's money
Is
exchange.
there a form for
There
that
is
now?
a form for
Is
that.
that
Yes.
me?
Mhm, mhm.
Good,
Yes,
because, I've had to do some of those.
yes, yeah. And
Especially in lake houses, things.
yeah, yeah. And the lender doesn't want to see those in, because then they think, oh, well, I'm financing all of this stuff as well in the loan, so they don't want to see those things. So whether there's money exchanged or not, there is a personal property bill of sale form that you can now put any of those additional higher priced items. Real estate commission, buyers strongly encouraged to conduct due diligence during the due diligence period. And then we get into all of the things within the due diligence period. So very first thing, loan. There is no loan or appraisal contingency in this contract. So when we are filling out the loan section of that, it is for disclosure purposes only. It does not mean that if you later find out that you can't get the loan, that you're able to terminate the contract. It's just, you're just saying the buyer is getting a conventional loan, or the buyer is getting an FHA loan.
Because a
Obviously,
lot of people don't want to sell VA and FHA.
yeah, I know, but it's a disclosure because we gotta have an addendum
Right.
if it's FHA or VA. So, again, from a buyer perspective, we want to make sure we're having the conversation with the lender. How long do you need in order to know that the buyer is, getting approved? I know a lot of times that depends on how quickly the buyer gets the information to the lender. Just makes it very clear that, again, it's not a contingency. We do not have a contingent contract. And then you've got all of your property investigations, your inspections, your review of documents. So, when your file gets kicked back because the property is in a subdivision and you didn't attach the subdivision restrictions, that's why your file got kicked back. So it says it's conditional on there until it's not conditional. So if it's in a subdivision, then it's required, you gotta load it. If it's not in a sub, that's the reason it's conditional, because if it's not, then, I can't require you to load something that doesn't exist. So we want to make sure that we are loading those restrictive covenants, and we are also giving those to the buyer as well. So we've got an email that says, hey, here's all the documents for the property that you're purchasing. Here's the flood map. Here's the restrictive covenants, that sort of thing. Because now we have a defensible position should any potential lawsuit or complaint with the real estate commission come up. So this person is a construction worker and he wants to make sure that he can park his enclosed trailer in his driveway in the subdivision. So if we didn't review that, and I'm not telling you to review or interpret. I'm telling you to provide. Hey, can I do that in this neighborhood? I don't know. Hold on. I'll send you the restrictive covenants and you read through them and see what you think. I'm not going to interpret it for them and be like, heck yeah, you're gonna have chickens, or whatever. I mean, whatever the case may be, here it is, you read through them. And because his definition of where he can park his trailer or how big his trailer is might be different than, if I read in there and it says, that, you can park your RV. All right, well, that's all that I know. Well, maybe then it becomes a whole lot, a whole lot more. So I'm not going to interpret. I'm going to provide them with the information and let them interpret it. And that's the reason why, because it's part of the due diligence, that's the reason that it is conditional until it's not in command. Insurance. Many of you have heard that insurance companies are not providing insurance coverage on homes that have roofs that are over 15 years old. So, many times with our buyers, we either fail to tell them or they wait to the last minute to get their insurance coverage, to call their insurance person and say, hey, I'm buying this house, get me a rider, get me a quote first. And then get me, and then if I approve the quote, because that's what's happening, is that they're either being denied insurance coverage or it's so expensive that they can't afford it with what the house payment is. So make sure you're doing that at as soon as you, as soon as you've been accepted, as soon as the contract's been
Now, is
accepted.
that common on conventional finance as well?
Mhm, it's across the board. Yeah, sure is.
Is that sort of new?
It is new, yes. Yes, and so, so how do we overcome it? Well, there's a couple of things. Number one, have the seller call their insurance company and see if they will cover. Because it now is not a new policy. It's in a new name, but you know, if the insurance company is already covering it, then sometimes I know, Kim Baber called her insurance company because she's selling her house right now. When this came up and they said, sure, they said, we'll cover them. It's just like Progressive might not cover them or, you know, whatever the case may be. And the other thing with that is, Matthew Young with Young Insurance, one of our preferred vendors, he's able to insure it as well, without not an unreasonable cost. Appraisal surveys, again, they want you to have a survey, flood, a wetland, water hazard. They just added, it used to just be flood. They added wetland, water hazard. Again, that's why we pulled the flood map. Utilities and access, streets, roads, and then this is where, they added, investigating special assessments.
Or down to how the weather's, the way the weather is now, it's flood everywhere.
Oh, yeah, I know, I know. All right, again, sale or lease of existing property. This contract is not conditioned upon the sale, lease, or closing of another property owned by the buyer. So that's also covered under the due diligence. And they put it in bold, it's always been there, but the property is being sold in its current condition. We don't need an as-is addendum. It already states it in the contract itself. Of course, unless agreed otherwise, if it's agreed otherwise, then there needs to be some sort of attorney drafted addendum.
So there is no contingent sale addendum anymore?
No. There hasn't been one in 3 years.
What?
Yeah.
Not a contingent sale addendum? So what do people do that have to sell before they buy?
So typically what we see is, number one is the house on the
Because
market.
It used to be in the offer, it's contingent on. Oh, that's right, I remember that.
Mhm.
Wasn't an addendum, it was in the offer. Now it's not even in the offer. So what are they supposed to do?
Well, no, it's still a
Still in.
disclosure. It's still a disclosure, but it's not contingent upon. Like, there's still a box that says buyer does, we'll get
They
there.
can say,
Yeah, yes,
But you just gotta sell it. I
Yeah.
mean, it's gotta sell
yeah, yeah. Or you risk losing,
everything.
I mean, yeah, your due diligence money, of course, and any additional or initial earnest money that might be in there.
If you go back.
Mhm. Yeah. Yep.
That's right, I remembered it wasn't an addendum then.
Yeah, back in the old school
But
day,
the
we
one
did
that
have a,
was- But now the one that was in the contract, it was contingent upon that, or wasn't? It was just notifying
yeah, so since 2023,
nothing.
with the
contingent.
with the new contract changes in 23, no contingent.
Okay, it was just information.
Yeah, disclosure, yes. Just a reminder, buyer's obligation to repair damage, anything that, may happen during the, inspection period. This would be like the home inspector falls through the ceiling when he's up in the attic, they gotta replace that. This does not include the home inspector jabbed his screwdriver into your rotting floor joists and more wood fell off. So they don't have to fix your floor joists. They got to fix your ceiling where the home inspector fell through. Closing constitutes acceptance of the property in its then existing condition unless revision is otherwise made in writing. Again, buyer's obligations under this contract are not conditioned on obtaining any loan. This is where we get into our disclosures here, Gary. But it's not contingent. If it's cash, they check cash. We love cash. If it's a loan, we are going to, check any and all applicable sources where funds may be coming from. And again, it's not contingent upon it. The loan type could change. They're just disclosing, this is the type of loan I'm going into this with the intents of giving. And here it reads right here, Gary, this subparagraph is only a disclosure by buyer and does not make this contract contingent on on the sale of the buyer's other property. If they want to make it contingent, then you need an attorney drafted addendum indicating so. So again, they either do or they don't have to sell. What is the property address? Again, is it under contract? If it's under contract, then I encourage you to ask for a copy of the offer to purchase. It can be redacted with the buyer's name, blacked out. And the way that the contract is now, I mean, really all you need is the first page. Because the rest of it, I mean, all of your terms are there, when the due diligence period, what the purchase price is, when the due diligence period ends, and when the settlement date is supposed to be. Now, if you got the whole thing, then you would know is their buyer have to sell, how many dominoes are happening here. And again, it either is listed, will be listed, or for sale by owner. All of that does is it changes your negotiation, your level of negotiation. So there you go, Josh. You can teach this class.
Yeah. I was probably more like buying a wife.
Again, residential RPOs and mineral oil gas. Timely payment of earnest money deposit and due diligence fee and dishonored funds. So when is due diligence money due?
24 hours.
3 days.
The effective date of the contract. Yes, the effective date of the contract. Earnest money, 5 days. So let's say that we're on day 3 and we still don't have the due diligence money from the buyer. Yet they've called and want to try to schedule inspections. There's a form 355, that is demand for monies. The seller has to notify the buyer in writing that I'm demanding this money. The buyer then has 24 hours to deliver certified funds or electronic transfer, or the seller can terminate the contract if monies are not delivered. You got to use that form. The seller has to notify in writing that we are demanding these funds.
That's something that's new to you there, right?
The form, well, it is, the dates aren't new. It's always, due diligence has always been the effective date.
Right,
And, earnest money has always been 5 days. The form of demand for monies is new, and a lot of people didn't know about it. I mean, it's not,
I just,
yep, it's not brand new to form changes that just happened in July. It was a form that was added last year. Yes, but a lot of people don't know about it, and that's why I wanted to make sure, because, you know, a lot of times people are like, well, what do I do if I don't have the earnest money, or I haven't gotten the due diligence check? Well, you demand it, is what you do, and, use Form 355 to demand. Again, if they don't deliver the funds, then, the seller has the right to terminate. This is where they move special assessments, just, because it states buyer shall take title, subject to all special assessments that may be approved following settlement. So that would be a case of the buyer says, there were no pending special assessments. But then the buyer moves into the house, and 2 months later, the HOA has a meeting, and they approve an assessment to replace the swimming pool. And now it's the responsibility of the buyer. And the buyer's like, well, you didn't tell me about it. Well, number one, we didn't know. And we also told you it was the responsibility. Anything that goes into effect after you purchase the property is their
But
responsibility.
what if it's a
If it's
pending,
pending,
what if it's a pending assessment?
yes,
If
so,
the seller already knows about it.
yes, so number one, it has to be disclosed. And pending assessments are, it depends, is really the answer. So if it's a pending assessment, and the monies are due prior to the closing date, the seller is responsible for that. If, like, in other words, if they say, okay, we have a pending assessment and we're gonna collect $2,000 this year, and then we're gonna collect $2,000 next year. The 2,000 this year would be the seller's responsibility. The 2,000 next year would be the buyer's responsibility. Then we've got our seller representations. This is where our lead-based paint has moved to, because that is a seller representation disclosure. Owners Association and dues, fill this information in, if there is an HOA. This expedites the, for the attorney. You're gonna have to get it anyway, so do it at time of offer so that it's very clear, and you've got all of this information on this one contract for your buyer that says, yes, here's the association, this is how much they are, all of that information on there. The listing agent should be able to provide that for you. Keep in mind, we have some lazy listing agents in our realtor community. And they don't put that information on the R codes, or have their seller put it on the R codes. That's where you should be able to find it. If they don't, then you can ask them for it, ask them to provide it. My backup option number 3 is always, if I see that the property was listed by what I'm gonna say, a good agent previously, then I'll go into MLS and pull the previous R codes and see if the information was in there. Now, it could have changed, the amounts could have changed, but the seller knows that information. The seller knows, the agent's just too lazy to ask the seller for it.
Yeah.
The seller knows that they are writing a check to an HOA, however often they are, and who they're writing it to, where they're sending it, and how much it is.
proper disclosure, you know?
Yeah. Yes, yes. Again, we've got our fuel tanks. Whether they are or are not in use, we want to disclose. So fuel, seller uses the fuel in the tank until the property closes. When the property closes, the fuel stays in the tank and it is transferred to the buyer at no cost. You can do, of course, the buyer can do, inspections. And supplier consent, that's just where we say, who's your propane service spot? And the answer is not, I don't know. Again, you pay in a bill every month. You know, and so, it's provided by, you know, whoever. All right, so the buyer then calls and says, hey, we're purchasing this house. Can we just keep the tank that's there, but would you guys go out and inspect it? And make sure it has to be the provider that does the inspection. It's not a, separate, like a home inspection, that's done on that. Seller's gonna provide, evidence of title and payoff to the closing attorney. Seller shall provide reasonable access to the property through closing. So they're gonna allow inspections, verify any negotiated repairs have been completed, conduct a final walkthrough. Again, reasonable access, that does not mean every day. That does not mean, oh, well, I want to ride by there and measure for curtains, or I want to ride by there and, you know, whatever. No. If we're gonna do that, then we're gonna schedule a time and we're gonna do it all at one time. And if your mom and daddy want to come, we're gonna do it all at the same time too.
Are you gonna do the vacant land after this?
Probably not.
Okay.
I'm
you have
probably,
time.
no, I'm not gonna have time.
Okay.
Settlement deliverables, this again is just saying that they just added it in here. It's always, the seller has always, signed a lien waiver at the settlement party. They just put it in here. So what they did on some of these things is they added some things into the contract that benefits the closing attorney and it also benefits the lender. Really, it benefits the closing attorney the most because the closing attorney was having to get all of these authorizations separate once you got the contract to them. Now, when it's already authorized. Like we already know, we can go ahead and move forward, which, you know.
Does that include getting payoffs?
Yes, it's the payoff is, or in you have to provide them to, I mean, you gotta provide the information
But They
to,
don't have to sign a.
that's
release
correct,
form.
yes, yes. General, want all of these, deed taxes and fees. So this line can be blank. If it is the same as the name on page 1 of the buyer, you don't have to put anything in there.
Won't be worth it.
Hmm.
But it doesn't matter. if
You can put it in there, just keep, Gary, you just keep putting it. And then, we get into, who pays owners association fees, charges, seller pays any charges by owner association management company. We're gonna get there, payment of special assessments, all special assessments that are approved prior to settlement, whether payable in a lump sum or future installments, provided that the amounts thereof can be reasonably determined or estimated. The payment of such estimated amounts shall be the final payment between the parties. Late listing penalties are paid by the seller. Any repairs will be made in a workmanlike manner.
Does the seller, they'll pay the transfer fees like, have the HOA charges?
There's certain, we'll get it spells it out. Yeah, we'll get there. Home warranty, speaking of, here we are right here. Charges by owner association. So seller shall pay, so this is what the seller's paying. Fee incurred by seller in completing the, R-codes disclosure and resale or other certificates related to a proposed sale of the property. Fees required for confirming seller's account payment information on the owner association dues. And any expedited fee that's charged in connection. So most of the time, the HOA drag their feet, they don't respond, and then you gotta have it, and they, oh, well, there's a $500 expedited fee added to that. Any fees charged for transferring or updating ownership records of the association, and any fees other than those fees specifically required to be paid by the buyer under B.
So the buyer pays the transfer fee.
So charges for providing the information to the lender,
Right,
working capital contributions, membership fees, charges imposed for buyer's use of common spaces, services provided to buyer in connection with buyer taking possession of the property, such as move-in fees, and that would be transfer fees. Yes,
okay, that's what
yes.
I was.
Or, so we,
Keep.
it does.
So it's the buyer now that
Pays the, yes.
transfer fee,
Yes.
so to speak.
Yeah, and also think about like, particularly like at Macintosh, okay, they have to create a new key for you to get into the pool. The buyer has to pay for the key.
Right.
And then also any charges for, determining restrictive covenant compliance. Prorations and adjustments, those have not changed. Delay in settlement has not changed. Addenda, this is where you attach any addenda. One that is either on here or something that was drafted by an attorney. The one thing you can put on here now is Form 220. Form 220 can be an addenda of your contract.
Great.
So compensation has never been a part of the contract. They're allowing it now because you have these agents, and these firms that, aren't paying compensation, like our firm continues to pay compensation. EXP, for example, does not pay compensation, the seller pays the co-broke compensation. So you call and you say, well, what's the compensation? Well, the seller's gonna pay, they just haven't decided how much they're gonna pay. Submit your 220 with your offer. Yeah, so that's exactly what's happening. And
Well,
so,
I have heard there are people that say they're not gonna give you what you make until you write the offer, they said the buyer will, Amber's to them. So, is that correct?
and so that's where you, your Form 220, which matches your buyer agency agreement. Okay, so whatever you have in your buyer agency agreement is what you put on that Form 220, and you send it with your offer.
Already go.
And you can identify it as as an addendum to the contract.
But it's not formally lit, you have to add it.
Yep, just check the box, identify other attorney or party drafted addenda, and you would just put Form
It's
220.
like they went on and made one.
It's probably gonna change again, so they will. It just got approved.
I
That,
remember seeing it.
so it'll probably be changed again.
It seems like we're circling all around commission And it's the same on same on. I just make it complicated for them. And then it's-
Yeah, I agree. I agree. Then, breach by buyer, breach by seller, what the remedies are. And then this is, so just be aware of this. Again, I like it because it reads as the eye reads. Remember, it used to be the buyer was on one side, the seller was on the other side. So it's just, from left to right now. Wire fraud, again, we don't get in the middle of that. Okay, last thing, and I apologize, we have run over. I just want to make sure that everybody understands this piece of it, because a lot of files that get returned because of this. So, Gary has a listing, and Stephen, you have a buyer. Okay, so when you're filling this out, number one, fill it out.
Yep,
All the information is on the MLS sheet,
both sides.
both sides. Fill it out. So,
Everybody does.
I do.
It's amazing. They don't even put their phone number. on.
lazy and rude. Yes,
I do
Yeah.
both sides.
yep. It's all,
I
all,
may not know the address.
yeah, but you know, if you're in MLS and you click on, then it'll pop up and give you the address.
How about what do you click on?
Their,
Icon.
click on, it'll be blue, like their name.
Turn half away. or-
Yeah, and it'll pop up and give you.
I
Yeah.
did not know that either.
I just meant it.
So, selling firm name. What are we putting?
The seller's name,
Nope, selling firm name,
that's the first.
Listing age. No, that's the fire.
selling. So on your side, Stephen, what are you putting? Selling firm name.
KW Century Realtors.
You got it. Gary, on your side, what are you putting?
Keller Williams Central.
Okay. Which one of these boxes are you checking?
I'm the buyer.
Jewel agent.
You're a dual agent.
Okay, oh, we're working, okay, that's what.
Because they're in the same,
Or we work the same firm.
same firm.
If it was two different firms, it'd be different.
That's correct.
Okay,
Yes.
you got it.
Yep. Dual agent. Firm license number. Okay, we all know what that is. We all know what our own mailing address is. Now we get to individual selling agent. So this is where Stephen puts his name
Right,
and checks that box.
okay.
If you have authorized this
If the,
listing agreement.
or the buyer,
buyer.
so they have to match.
So if one doesn't match, you gotta make it match
That's
before it closes.
Keep that coming.
Well, I mean, if you get it returned, like I'll put a statement in there to say because like in your case, because you do same agent, dual agency. Some people don't. Stephen does same agent, dual agency. Okay, so your buyer agency agreement or your listing agreement might say it does authorize the firm or authorize the same agent
Right.
to practice dual agency, which is fine. We just gotta change it when we get to here. It depends. We gotta have a conversation, first of all. So if your client is fine with you being a dual agent and your client is fine with you being a dual agent and doesn't want you to be a designated dual agent, then you can keep your paperwork as it is. It's only when they want that designated. Yes, yes. And just remember, our fiduciary responsibility changes between dual and designated dual. So that's where we just have to make sure is, how are we representing the client?
Almost like neutral. You know, if you're doing both sides. Like I-
Well, even if you're not both sides, even if it's still Gary's listing
Right.
and your buyer, again, it's the difference between dual and it's the same thing. You know,
You're not automatically designated just because you're in the same firm.
that's correct. Has to be authorized. But it also need to make sure that we're explaining the difference between dual agency and designated dual agency. Hey, honey, don't forget to, let me know which class you want to teach. Oh, yeah. Yeah. Okay,
I'll look at it.
okay, thank you.
Thank you.
Thank you. Any questions?
That's something that,
Okay. There are some changes to the, next week will be, miscellaneous forms. There are some pretty significant changes to, miscellaneous forms. So those are our forms that we don't always use on a regular basis, like our additional provisions addendum. Those sorts of things is what we'll go through. So we'll go through several forms. The biggest changes are the termination forms. So we used to have 8 and now we only have 4, which is a good thing. Yet still knowing when do I use this one versus when do I use this one and.
yeah, that's what the problem comes in.
Yes, yes. So, that's what our, primary focus is going to be, will be termination forms just because they're brand new. And then we'll be able to knock out some of the other forms on just what the changes or additions were.
Since I missed it, I want to go back to one thing on seller concessions. So it's saying that if you give 3,000 in closing costs and you want it to pay for the termite, the buyer wants to pay for the termite on the HUD. Even though the lender says buyer can't pay for the termite, this overrides that.
Well, I mean, ultimately, the lender determines what the closing costs can be used for. But it could be used for something else. So the buyer's not spending the 3,000 on the, on the termites, but they're spending 3,000, so it all balances out.
But what I'm saying is, it says here that they can use it including for things not allowed by the lender. Including lender and inspection costs that buyer is not permitted to pay. I'm confused. The seller would be paid. Oh. Sorry.
Okay.
I was getting.
Yeah, yeah. No worries, no worries.
Thank you.
Yes, thank you. Yeah, thanks for being here. Kathy, thanks for joining us.
Seen you in a while.
Some working from the house, and I've been working on my own project at home too, so I'm trying to, flip together, but this flip is for me.
Are you doing a lot of?
Are you gonna try,
And I got some kind